we as a nation, especially the courts, will have to draw a distinction between judicial matters that have been put to rest and judicial matters that are pending or are likely, to be gone into. Where a judge or a committee makes a ruling and it is finished, as far as that issue or question is concerned, commenting on it, is not contemptuous of the court. Because it's been done, it's been executed, it's been consummated, finished. You see, elsewhere, they will say that a judge has become functus officio, and therefore, in the interest of the public, the citizenry must be encouraged to look at what has happened. The contemptuous aspect will, arise where the matter is pending and a comment is made on it, but not to matters, that have been exhausted. So that's my, comment. And then, that Edu Lodge, I think soberly, we need to appreciate that there are certain memories that evoke sadness. And if she says that she was living with the uncle at the time, and she, recalls with, sadness and nostalgic feelings, the events of that day, and asking her to go back, to that very venue, was too much for her. I think as a nation, we should accept that and try to right the wrong. So my appeal to the committee will be, if indeed, there's concrete or hard evidence that, the uncle was one of the victims of the, June 30th Dastardly Act, I don't think it is fair for the nation to put her, through that sad memory. I don't think, it was right. And it is still not right. And I don't think it would be right to ask her to go back. So that we should, find an alternative venue which would be friendly. He has mentioned Article 19. Fair trial includes, the absence of evocative, memories, such as, murder of a relative. I think we've nodded a little bit, and the right thing, must be done. Now, about this whole press conference, I think that it was unexpected and in clear violation of Article 146.
How did they violate Article 146 exactly?
Unexpected. A Chief Justice or a Justice of the Superior Court or a chairperson of the Regional Tribunal must not do that. That is what, the Constitution says should not be done. The Constitution says that the entire proceedings must be held in camera. So once you are a participant, you cannot, as it were, do, what the Constitution says you should not do. So it was unexpected. She did it. She has alleged 6 violations, but that's the very first fundamental violation, coming, as it were, from the chief judge, who is in charge of the entire civil justice system, the entire criminal justice system. So it was unbecoming. It was also disrespectful.
Disrespectful to who?
Very disrespectful because, she being the Chief Justice knows that when you go to court, all answers and questions, are to the judge, to the court. So if a litigant is being, uncivilly, the litigant or the party or witness is reminded that you are before the court and your answers are to the court, your questions are to the court. So be civil, be decent, show some, decorum. And she being, the number one, person to uphold and defend that process, and then sacrificing it, to the altar of frustration, I think, was another for, I mean, she shouldn't have done that. The president set up the committee. Any attack, any onslaught is directed, at the president. So she ought to know that what she was doing was disrespectful to the first gentleman.
Disrespectful to the president?
To the president, yes, the first gentleman. And that's, why I say that she should eat a humble pie and apologize to the whole nation. That this is something, upon sober reflection, she shouldn't have done, but she was driven, as a result of the, frustrations, within her, and she felt, she should voice them out. But next time, she may not do that. We all err sometimes. Not only was it unexpected.
You're expecting the suspended chief justice to apologize to the nation? To
the nation, yes.
For addressing the press conference?
Yes, because, she's been boxed into Article 146(8). You see, Article 146 carries 11 clauses. And each clause, the president is reasonably expected to act. So if you look at, Article 146(9), the president, every step the president takes must be in accordance with the Constitution. So the chief judge, and interestingly, my friend said it is the chief justice who administers the oath and will say, Mr. President, repeat after me. Repeat after me. And when we vary, the positions, and this is the chief justice, who is subscribing the oath, the president, repeat after me. So both go through the drama. And one cannot therefore outmaneuver the other person and say that, so for me, it is something that should never ever happen. But maybe, as Martin Pebu, rightly indicated, a future amendment, should deal with this issue. I don't think it is fair. I have, been a victim myself before, so I know how one feels within. It is not fair, to tell a person that even though you are in the boxing ring, we are going to tie your two hands, and your back, and then the other person will continue hitting you. It is not fair, so we all have to do something about it. No judge is above the law. Not even the president is above the law. All of us are, subject to the law. And Martin Pebu said, you look at Article 17, equality before the law, it is addressed to everyone. It's not only, to the downtrodden, to everyone, including, the president. So that act of disrespect must be addressed by her and the legal team.
I see.
Then it was also unacceptable. Her whole conduct in taking to the press, must be roundly condemned.
Why
unacceptable.
Is that? She stated four specific reasons why
the Constitution says,
she did that.
The Constitution says, look, when Article 146 is triggered, anything you do, the water you drink, the food you eat, the air you breathe, must be in consonance with Article 146(8). So even if you have reservations, please keep them to yourself, close to chest, at the appropriate time, and the appropriate time is when, everything is over. That would be the appropriate time, to, vent your anger, your spleen, whatever, on that. But not while, the committee, is still, functioning. And you are, after the press, she will go back. She's saying that she's not going to appear. That again will be a serious violation of the Constitution. So she will have to go back. Now, after doing this, what do you expect? When you go back, you have attacked, the committee members. They are doing, what the Constitution, bids them to do. So if Article 146 Clause 8 says that the proceedings are in camera, what it means is that none, of the events must be done in the glare of the public. That is why it is in camera. So in that regard, it's unacceptable, and I think that again, she will have the opportunity, to do some sober reflection, and if she will take my advice, if she doesn't want to do it publicly, she can write, something to the president. I'm sorry for what I did. At the end of the day, it is for the general public to judge. So history is going to judge whether she was treated fairly or unfairly. If you look at the genesis, of this whole thing, it started with her appointment. It started with her. So if she is, alleging violations of the Constitution, her appointment was in clear violation, of the Constitution. The very Constitution she is now alleging is being, reading roughshod, over her.
I see. Her appointment as Chief Justice?
Yes.
Violated the Constitution?
Yes.
At what point exactly?
Because, you see, at the time of a nomination, Article 146, 4 had made a certain, 144 had made a certain, process that the most senior should act. If the most senior should act, and you go and, invite one who is not, one of the seniors to act, because the most senior means the one who is topmost, you see.
So in this
and
case,
in that ranking, so you have, the most senior, the next most senior, the next most senior, in that order. And therefore, the moment the nomination, was made, I remember on this same platform, drawing attention to what was likely to happen if, and I cautioned that, Mr. President, I hope that this will be the last such appointment where, someone will be, taken out of 10 and appointed to the high citadel, of Chief Justice of the Republic. I made that, clear. And I even, concluded with the bida metu jum asemi mihumeka yo enuna that one. I sang that, this thing.
Sure.
And that is what is playing out now. As if, divinely, I had some, hint that it will happen. But I'm a lawyer, a very senior lawyer, and I have always, taken the position that seniority must be respected. I've not been happy, with the appointment of attorney generals, between 12 and 15 years. And no, it is wrong. You take a Chief Justice, there are about 10, justices of the Supreme Court, you go and pick the 11th. You are, as it were, destroying the very fabric of the judiciary. So because when you do that, junior person is not going to get the cooperation of the seniors, and he or she will see himself or herself, as being, on the, side, alone, single-handedly. So she will, by all means, make recommendations to the president, and that's exactly what she did. Bring in people I can work with. Again, I spoke against it. Don't do that, because if you do that, we are going to have pockets, of supporters within, the Supreme Court. So 5 people on the side of the Chief Justice, another 3 on the side of the most senior, another 3 on the side of the next most senior. Is not good, for our, justice delivery system. It has happened. What do we do next? So even though the press conference was unexpected, it was disrespectful, it was, unacceptable, nevertheless, it's food for thought, and it's a wake-up call that we have been living or coexisting with an ailing judiciary that now needs, some serious emergency operation. And
an ailing judiciary that needs serious emergency operation.
Surgical operation.